is up, ladies and gentlemen? We are back. We are live. It is the Freight Coach Podcast, the top podcast in transportation, coming to you guys every single weekday, 8:30 a.m. Pacific, 10:30 Central, to break down some industry headlines. But most importantly, provide some actual insight into what you can do with all of this information. If this is your first time tuning in, welcome. This is the real side of freight, ladies and gentlemen. And I say that before every single show. And what I mean by that is I only speak with transportation professionals because at the end of the day, I want to talk to the right individuals who have done what you're looking to do or who are currently doing what you're trying to achieve. So you can take that information, apply it, utilize it, and see a meaningful difference in your business and your life. We are going to jump right in because we got a lot to talk about, but my guest has a day job, so he's got to jump a couple minutes early. And this is like probably the most important case that might happen in 2026 in regards to freight brokerages out there. So the man, the myth, the legend, Mr. Armchair Attorney, aka Matt Leffler, back on the show. Matt, always great to have you, sir.
I fought the law and the law won. And so I joined the law. Great to see you, Chris. How you been, my friend?
Dude, I don't know how I'm feeling about you in green. Like, you've always been in that red jacket the entire time. That was kind of like your calling card here. So, but
it remains that way. It's right. I see it in my vision right now. It's just fresh out of the dry cleaner. It'll be around again very soon.
All right, man. I mean, lawyers got to wear those, those sport coats. You guys got to look official. That's why you charge $500 plus an hour. But anyways, speaking of lawyers, speaking of court and everything, I really want to dive right into this, man, because this is what's going on right now. Is I think could legitimately, depending on how it goes, could legitimately change the landscape of the industry, right? And I want to say this before we jump in. I think people need to understand what C.H. Robinson is doing for the brokerage industry as a whole.
Yeah, that's a great point. Absolutely.
They're taking a lot of arrows, whatever you want to call it, to go and fight for this stuff, right? So it's like, I know a lot of big companies out there get crapped on a lot in the media about a lot of stuff, but let's be honest, man, these guys are leading the charge with this that could potentially change the way how I make money moving forward as a freight broker.
Yeah, I think that's a great way to segue in talking about this case. The Montgomery case, which is the one that C.H. Robinson is in front of the U.S. Supreme Court, is the most important case for freight brokers in the country. At issue is whether or not a broker can be held liable for negligently or allegedly negligently hiring a motor carrier. When can a broker be responsible when a trucking company has a catastrophic accident? And this is all governed by a federal statute called F4A, which kind of is this Federal Aviation Administration Authorization Act. Don't worry about the airplane part. This is about brokers. Yeah. And we're going to get some clarity in the months ahead.
I think that, so for those of you who are keeping score out there, F4A, it was put in 1994. And on top of it, it states that, I look at this, because as somebody who actively moves freight, again, I'm not just a pretty face. I'm out here actively moving freight every single day. And it's like, at what point does your liability on who you choose to haul that freight end? If you follow all of the information that's out there, that's publicly available to you, right? And it shows that you were not negligent in how you chose that carrier. Because I think that that's what gets people in trouble, right? Is it's like you disregard all the warning signs, right? Like lapse in insurance, everything that's wrong, but you're like, oh, let's just roll the dice. They're the cheapest truck. We got to make money on this. There's a difference between that and then choosing a carrier that was clean on paper, like all the public information that we're expected to use as a broker, and then something happens after the fact. That's where, for me, it's like, how is that on us? We did everything.
Yeah, I mean, this is the main goal of F4A, at least as it relates to freight brokers, is to say, okay, we need some uniformity and some consistency with how this particular type of group, the freight brokers, how they interact with transportation. And brokers are there for price, route, and service. They're not guarantors who step in and say, well, that motor carrier failed, so it's my fault, and I'll get you. We'll take the liability. It's really about connecting the dots from the shipper who needs to get something moved to the trucking company that can actually move it, and the broker takes the delta. I'd like to use an example for the audience to kind of unpack how broker liability practically works. But I'll use the example of the Hope Trans case. So Hope Trans, everyone saw this story last year. It was a motor carrier, about 100 power units. The driver was moving stuff for USPS, and the broker was Covenant Logistics.
Yeah.
And the driver fell asleep. Killed a family. And the question was, okay, well, should the broker be held responsible? That is actively going on. That case is actively going on. And ultimately, what the broker can do is they can check and see, are you registered with the federal government? Have you complied with your records? Do you give me tracking access? But can a broker be in charge of whether the driver falls asleep or not? The answer is no. Like, the broker's not in a position to do this. But what we see happening, Chris, is that people look at the trucking company and say they're a victim just as much as the person who got in the accident is. And the trucking company may not have enough money to cover this liability. So they look at the broker and they say, you, Mr. or Mrs. Broker, you should be on the hook. Now, where this case really is important for everyone to understand is that F4A language, like whether the broker can be held liable at all, it's been looked at by a whole bunch of federal circuits, which are the courts in the middle. So there's the Supreme Court, the appellate courts, and the district courts. And the appellate courts have gotten different answers. Some courts say, yeah, the broker can be held responsible. Sometimes they say no. And so we've had this chaos among the circuits. And that's partially why the U.S. Supreme Court granted certiorari in this case.
Why? Like, I know obviously everybody, you and I could see the exact same thing or read the exact same thing and get two completely different perspectives based on that. Why is that? How does that happen in regards to the law, right? Like, you would think it would be very cut and dry, very black and white in how it's done. Like, I don't see how there's gray area that comes into it. Like, because you're talking about the lower circuit courts and how one can say this, but then another can say that, and they're basing it off the same thing. I'm assuming the exact same arguments are being made by attorneys. Everything's probably the same, right?
Yeah. So this is a really important aspect of law that doesn't really get talked about, not just in legal circles, but in any circles, is how you interpret words. Words have meanings. You can look at what Congress said when they made the document. They could look at the document itself. And these courts will look and go, well, there's this safety exception. There's this part that says if the state has some regulatory piece of safety, it allows us to go after the intermediary. And so this is the real question is, when you say there's federal preemption, this safety aspect is, are common law negligence claims, like I sue somebody because they changed lanes and they smashed me, is that type of litigation a safety regulation? And some courts have said, yeah, we think that this is the state's power. So this is why this case is so interesting, and why I love talking about it. If you look and see who has filed amicus briefs, friends of the court briefs in this case, you see this incredible grouping of personas. On the one hand, you have the plaintiff who says, I think brokers should be liable, but right alongside them are 29 states led by the state of Ohio and the District of Columbia. So liberal and conservative states are saying, we states want to have access to sue the broker because this truck wouldn't have been here if this broker wasn't involved. And so you have this one side saying we want brokers, and the other side is even more compelling. We'll talk about that in a moment.
What does the FMCSA stand for?
Well, so that's the question. The Federal Motor Carrier Safety Administration. They care about safety, but they also do regulate brokers in a variety of ways, but they don't require brokers to carry liability insurance like these cases would indicate that you might need to. Okay.
So, and again, I'd like to make it abundantly clear here. By law, freight brokers are only required to carry a $75,000 bond.
That's right.
That's it. Brokers are not required to carry insurance by law. I would assume C.H. Robinson has insurance. Just putting that out there.
They're going to be okay.
Yeah, but most brokers, most brokers who are moving high volumes of freight carry insurance because all of our shippers require us to carry insurance, right? So my stance is like when we as a broker use the FMCSA's data. The FMCSA is what we have always been plugged into via the DOT number or the MC number to check the validity of said carrier that we are hiring, right? Are they who they say they are? Do they carry active insurance? Now we have fancy onboarding tools that we can use that plug all of that data in for us, and it shows us a bunch of great information that's out there. But ultimately, we rely on the FMCSA's data that helps us make these decisions out there, right? So from my stance, the way that I perceive this is if the FMCSA says it is okay for me to book this truck, then it should be okay for me to book this truck. So like, how does that liability, how do you separate that as a broker when we are using FMCSA, Federal Motor Carrier Safety Association data to book trucks as a freight broker? Where's the clear separation there?
Yeah, this is the real challenge. And the case really kind of highlights this problem. The vast majority of motor carriers are small, and those small motor carriers have very little information inside the FMCSA. They just don't know about all these motor carriers. And so brokers have to rely on third parties, whether that's Highway or it's RMIS or any number of these platforms that can tell you this is who I say I am and this is who I actually am. And ultimately, the brokers are not in a position to enforce the safety regulations on the books. That's just not what they're good at doing. And so when the FMCSA, as well as the Department of Transportation, as well as the Department of Justice, filed an amicus brief in this case, they're on the side of C.H. Robinson. They say, look, if there's a lapse in data, that's our job to figure out. That is not up to the brokers to go out there and do a ton of extra stuff that they just don't have the expertise to do. So the government is actually on the side of C.H. Robinson in this case, which is not what happened under the Biden administration. Under Biden, they were very much in favor of brokers having some level of liability when it comes to negligent hiring cases.
Let me ask you this. Was there a clear indication that the carrier that they hired was negligent in any way, shape, or form? Did they have any auto service record? Did they have any high safety scores due to accidents? Was there any clear indication that maybe Robinson made a mistake in booking that truck?
I think the answer is no. What really happens in these cases is that the carrier is good enough. They are allowed to haul freight under the FMCSA. They have valid insurance. They're doing what they do. But what ends up happening is something catastrophic, whether someone falls asleep or someone gets distracted or whatever else can possibly happen. When that thing takes place, the plaintiff, the person who's injured, looks and says, okay, who has some culpability? Where can I get this money from? And we've talked about this in your show previously, but the minimum insurance for an over-the-road motor carrier hauling general freight is $750,000. That's a couple weeks in the hospital. But these big brokers, and there's a lot of big ones, they have insurance and they have the capability. So plaintiffs are looking at them. So that's the question. It's not like, was this carrier dangerous when we hired them? It's they had an accident after I booked them. And am I on the hook for them being booked? I don't know. And that's the question before the Supreme Court.
No, for sure. And I'm just kind of throwing this out there from a conversation piece, right? Because I feel like I'm trying to show people that, you know, there is negligent hiring practices that go on. And like because like when I was coming up in the industry working for a large 3-letter brokerage, there were certain safety thresholds that if it did not matter. If they were above it, we could not book them under any circumstances. So I think brokers need to be aware, like, hey, there are data points out there that show, you know, and again, you can't make up crash data. You can't make up drug and alcohol violations, right? Like you can't just like, oh, all of a sudden, like.
To build off that, like the crash data is probably not the best data for you to make decisions off of. Like, don't take legal advice from a podcast. If you think you need a lawyer, you probably do. You should hire one. But crash data is an accident occurred. It has no bearing on fault. So a motor carrier necessarily can't really control crash data if someone rear ends them, for example. But the things they can control, to your point, driver qualification, driver out of service, those things, and vehicle maintenance. You can control those things. And that can tell you a lot about the motor carrier. But a lot of them have no data at all. And that's the challenge the FMCSA has to tackle. It is not a challenge for brokers to try and solve.
I just look at it like this, you know, my honest assessment, you know, and again, I always like to preface everything I say on the show. I could be wrong, and my opinion could change if there are any additional facts that are presented to me. But based on what I see, it looks like there is certain states out there that want to keep the brokers in from a lawsuit standpoint only, right?
Yeah,
Because like
sure.
at what point, like if you own the trucking company, you hired the driver makes a mistake. Why is it the broker and makes a mistake on the road? Let me go a little bit further on this. This is on the freeway. The driver is in possession of the freight. The broker booked him on that load, but they're in possession of this freight. Maybe they are going too fast for conditions, and unfortunately, there's an accident, fatal or severe injury that happens out there. How is a broker ever brought into that when there's no proof that shows the broker was telling them, keep driving through the storm, you're going to get blah, 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 blah. Like, I think that there's a clear line of, I'm drawing a blank on the word here, but like malice, right? Like there's a clear, like, and if that didn't exist, like at what point is it the driver's responsibility for the truck?
Yeah, to unpack that a little bit. So the couple of ways you can try to get a broker on the hook for something that a driver does. One is we're talking about now is the negligent hiring. Hey, broker, you had a process, you deviated from the process, you got this motor carrier who is not safe. They had an accident. You should have known. You're on the hook. The other way that happens, and this is far more rare, but it does happen from time to time with usually with poor training, is when you kind of become the driver's boss and you say, hey, this is where you're going to go. You're going to go. Then you start controlling them. Then you're no longer contractor and subcontractor. Now you're an employer, and that can absolutely circumvent the F4A preemption if you don't do it right.
Now, memory, I might be a little bit foggy on this, but I believe it was Robinson who had a load back in maybe the early 2000s. It was pretty much like right before I came into the industry, because I remember I was specifically told never give directions.
That's right.
Any circumstances, because I believe it was a Robinson load. And again, I could be wrong. So please, 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 my friends at CH Robinson, I'm not accusing anybody of
it's
that.
every every broker's had this in their time. They've had
but there was a specific case that was referenced when I first got into the industry that, hey, this broker told this driver to go down this street, and then like they actually hit, I believe they hit and killed somebody. And it went down. So again, like never give directions out, right? Like there is a fine line, and that's where it's like, I see a lot of this stuff out there, and this isn't related to the case, but it kind of is about broker responsibility. I mean, I see blatant violations on social media of people all the time when they're screenshotting text messages and emails, like, look at what this broker is telling me. And these are not like one-off companies. These are like top 100 freight brokerages. So like, again, I think brokers, you got to be very smart about what you do and say in that transaction.
Well, and this is what really kind of brings back why the states came out against C.H. Robinson. The states are saying, look, it's my citizen who's involved in this accident. This trucking company came into my state. They had an accident. They killed one of my citizens. And I want to go after the trucking company for sure. But I also want to go after the broker who came into my neck of the woods for no other reason to make money. And they had this accident. So we have this really interesting argument by the states. On the other side, not only do we have the U.S. government, but we have the U.S. Chamber of Commerce. And the U.S. Chamber of Commerce has an 80% success rate before the Supreme Court of the United States. Like when they come knocking, they usually win. And they come up with the exact kind of arguments that the TIA advances, that Robinson advances, and says, look, we have a federal system to regulate these things. If you allow all of these small cases in the state courts and in the federal courts, it becomes an absolute mosaic. It becomes chaos. There's no uniformity. And we need this. And what I tell people, and again, this is me kind of reading through the tea leaves. I think C.H. Robinson wins this. I don't see a way that they lose. But if people say, well, I still think brokers ought to be responsible. Okay. Go back to Congress and have them change the law. They can change anything that they want to, if they really want to.
Yeah, you just stole my next question of what we were going to go with here on is like, how do you think this kind of shakes out, right? Because like from my perspective, and again, I don't know all the intricacies of this specific case, but I know that transaction very well because I actually book trucks out there, right? And it's like, there is a fine line and that when the broker's responsibility ends, and if you can prove beyond a shadow of a doubt that there was no negligence out there of a broker telling a driver to specifically ignore weather or whatever else that put them in a situation, like there's a difference that's there. And the fact that that hasn't been brought up, like I think that I think they're going to win as well. I truly do. But I think that if it goes the opposite direction, it changes a lot.
Yeah. So let's unpack that. So
there's going to be a lot of lawsuits that are going to come down from this if it doesn't go the way of Robinson.
What I would say is, and it's already kind of moving this direction already, which is if there is an accident and a broker is involved in any way, we're going to sue the broker too. And when you have liability insurance for these types of issues, you get two things. One is the duty to defend. So the insurance company pays for your cost to fight the litigation. And there's a duty to indemnify. They pay on your behalf if you're found liable. So these two things, if you don't have the insurance that gives you the duty to defend, you are going to pay this out of pocket. And most small brokers are not capable of advancing $20,000, $30,000, $40,000 a month to deal with this type of litigation. So that's one thing that changes immediately. If we say, okay, brokers can be liable, what is the insurance that they ought to require? There's no statute that requires brokers to have liability insurance. But if the Supreme Court says maybe you're going to be liable in some cases, it'd probably be the same $750,000 policy that motor carriers have, which again is not enough, but it is what the law requires. So you're going to have a lot of brokers who are really not able to get to that level, and maybe they go away. I think it just forces the industry to consolidate a lot more. But ultimately, I think we kind of agree. I don't see SCOTUS going the route of the petitioners. I don't think they go with the plaintiff. I think C.H. Robinson, TIA, the U.S. Chamber of Commerce, the U.S. government, I think they're going to win out over the 29 states and the District of Columbia and the plaintiff's attorneys.
Do you think if there was a different administration in office that it could go the other direction? Because you had said that the Biden administration was that. And is this something that in the future, because again, there could be a change of administration. Could they overrule this in any way, shape, or form in the future?
Yeah. So obviously they could always be overturned. There's this idea in Supreme Court jurisprudence called stare decisis. Like, we've decided on this once before, we're never going to look at it again. That's cool, but that's not how it works anymore. If they change the court, it would be a substantial change. This court right now is probably one of the most conservative Supreme Courts in 100 years. And that is for C.H. Robinson and others. That's a good indication. That's a good indication that they will be successful. Now, when it comes to like the other administrations, sure, the Biden administration was certainly in favor of holding brokers liable, but that Supreme Court was still the same people. And so they probably wouldn't be successful. My feeling is once this case is decided, it will just increase the need for the FMCSA and the Department of Transportations across the country to kind of step up their game and have more inspections and do more auditing, because that's the only way you can tell if a motor carrier is safe to utilize. And that is probably the right outcome. Maybe we have regulation down the road, like the Congress passes a bill that says we're going to keep this type of liability on the hook for brokers and this one goes away. They could also, Chris, like split the baby and say, okay, we're going to have gross negligence. So if you're really, really incompetent, so the broker who booked the trucking company, they were drunk, they didn't vet them, maybe that gives you a way to get around the preemption. But I think generally speaking, federal preemption will be the law of the land across the country when it comes to broker liability.
No, Matt, I appreciate it. I'm going to lock you in for March. We'll talk off air here about getting you locked in, because I want you to come back on around the time that this is decided.
March 4th, baby. We're going to have live oral arguments. You can listen to your government in action.
Dude, there we go. Matt's got to jump, you guys, because he's got a day job. Matt, put your information out there for people if they want to reach out. Just find you on LinkedIn.
Find me screaming on the internet or armchairattorney.com. Thanks for having me, Chris. Always a pleasure to see you, my friend.
Absolutely, brother. Have a good rest of your day, you guys. Matt's got a day job to jump out to, so we'll see you later, Matt. I appreciate it. We're off.
Take care.
All right, you guys. We got a couple of minutes left here on the show. Again, I just to highlight a couple of key things. If you want to go out there and look at this case in particular, it's F4A. That's Federal Aviation Administration Authorization Act of 1994. That's the verbiage that is being talked about in this. It's C.H. Robinson that is going to be fighting this on March 4th. There has been countless articles released out there. I believe FreightWaves most recently had one. So again, if you guys want to read up on all of this stuff, educate yourself, you guys, because I think when it boils down to it, I feel like at times, brokers feel like we're not necessarily liable for a lot of what happens out there on the roadway. And as I discussed in the show, there is a fine, fine line between knowingly being negligent in how you select a carrier and you following all of the data that is out there and at your disposal, and then something happening after the fact. So this could potentially, and again, I don't think Robinson's going to lose this at all. I hope they don't, because that would really shake up the industry a lot. But again, you guys, you got to pay attention to this stuff. And like I was alluding to at the beginning of the show, a lot of these large brokers out there, they take a lot of heat on social media from a lot of people, some warranted, some not warranted at all. But these ones are fighting the battles for us on Capitol Hill. They are the ones who are out there fighting for this. Like the TIA is out there fighting on Capitol Hill for, to put bills in there to protect us as freight brokers. So check this out, you guys. Research this stuff. Get up to date on this stuff. You need to be aware of what you're potentially liable for in the event that something happens. But that is going to be it for today, ladies and gentlemen. We got a newsletter dropping tomorrow. If you've made it this far in the stream, which the viewership has stayed up the entire time, go to thefreightcoach.com to check it out. All right. It just drops on Wednesday. It's all industry related. We, with our new partnership with DAT, you guys, we have the weekly market report is going to be in that as well. So if you despise hearing me talk about it on the show, we're going to break it down, and it's just going to be in a clean way for you to read it in our newsletter. It just drops once a week. I don't even know who signs up for it. I just pay for the software that we use to distribute it. I don't even know who's registered for it. So I don't even have access to that information. But if you want to get in on it, go to thefreightcoach.com. That is going to be it for today, ladies and gentlemen. Again, we're going to be breaking down a reefer lane analysis tomorrow on the show. If you want any of those lanes, or if you need help reading the market for the where you're currently moving freight, email my team, podcast@thefreightcoach.com. All I need you to do is put shipping city, delivery city. That's it. We'll handle the rest. We'll break down that lane, and we'll help you guys actually understand what's going on out there from a broker's perspective, who actually moves freight, who actually wins freight, and has customers as well. I appreciate you guys. I love you guys, and we'll be talking to you soon.